There you go.
Yep. Thank you everyone for joining. Sorry we got started a minute or two late. We're just going to wait for additional folks to continue to file into the virtual room here. In the meantime, everyone should see a poll question on their screen if you'd like to go ahead and participate. We'll get started momentarily.
Thanks everybody for joining. I know we're going to sit here for a minute or so, somewhat awkwardly, but I think we need just a minute while folks fill the room.
We'll just give it another moment or so, let the last few folks come in. As I mentioned, everyone should see a poll question on their screen, so please feel free to go ahead and participate in the poll, and then we'll share the results here in a moment. Okay, great. All right, great. So I think we can go ahead and get started. Thank you, everyone. As you can see now that the poll results should be showing on your screen. Thank you for those who participated. And thank you for joining us for today's Privacy Tech Leaders panel. My name is Mark LaFleur, and I'll be your Wire Wheel host for this session. Before I introduce the moderator, I'd like to cover a few housekeeping items. Please note that the views expressed here today by the speakers are their own and not the views of their organization. And also, we do hope that these sessions will be interactive, so please feel free to submit any questions that you have via the Q&A feature in Zoom at any time. Please do not submit questions via the chat box. With that, I'm excited to introduce your moderator for today's session. Justin Antoni-Pillay is the founder and CEO of Wirewheel. Justin, I'll pass it over to you to introduce our panelists, and I'll be back at the end of the session to help wrap things up.
Terrific. Mark, thanks so much. First of all, everybody, welcome to our session today, our Privacy Leaders session. And I think for the viewers right now, Mark, it may still be spotlighting you, so you may need to switch it off just for that purpose. But first of all, welcome everybody. We had a phenomenal number of opening sessions here at Spokes. Judy, I don't know if you and Mark can switch it. Are you able to switch the spotlight on the Zoom? There you go. Okay, great. So we had a phenomenal opening session, as everybody knows, yesterday with Cam Carey and Alex Reeves-Givens. And thousands of people have viewed that just even in the last day or so. A terrific first session this morning, and I am biased. Tara Antoni-Pillay, my wife, hosted a session on managing stress in the privacy profession. There's been a lot of folks having to deal with smaller budgets. It's a tough time for a lot of us, and I was excited to see so many folks be able to take advantage of that. We just had a terrific session with Bruno Gencarelli. Now, dramatically, Bruno is in the middle of discussions in London around Brexit and has been drawn away at the end of the session. But in the last session today, we covered a lot around where things stand in the Brexit discussions, what's coming next in the transatlantic relationship with the release of a paper today from the European Commission on where the priorities will be. We discussed Privacy Shield and really encouraging to hear all of the work that's going on both sides of the Atlantic to get a new Privacy Shield in place, which, as we know, is so important to so many small and certainly small and medium-sized companies and other companies around the world. And then we talked about the guidance that's been coming out on standard contractual clauses, but it was really about a broader conversation that Bruno and I had around how companies who are trying to do the right thing can still deal with some of the issues around national data collection, which again, Julie, Lindsay, Gabriella, you all have spoken a lot on these issues, so I think very, very familiar to each of you. But I would like to say this is our Privacy Leaders panel, and we have an amazing panel today. So briefly to introduce good friends all, Julie Brill is the Corporate Vice President, Deputy General Counsel, and Chief Privacy Officer of a little company called Microsoft, who I hope some of you have heard of. Julie, it's great to have you here today.
Thank you for having me.
Lindsay Finch, we have another small company represented, Executive Vice President, Global Privacy and Product Lead at Salesforce. Lindsay, great to have you join. Thank you for coming.
Having us.
And Gabriella Zanfir Fortuna, who's the Senior Counsel of the Future of Privacy Forum and one of the leading voices on European data privacy, data protection around the world. Gabriella, thank you very much for joining us here today.
My pleasure.
Let me say one more thing. We have an amazing group of attendees. I can see, again, PhDs in privacy, data protection, many of them. Please share your questions with the panel in the Q&A, and we'll take them as we go today. And we have a lot to cover. So with that, what I wanted to start with for our panel is obviously all around the world, one of the number one or two issues all of us are dealing with in our communities, in our companies, has really probably been much more around the global pandemic, all of the stress that's causing to our team members, our communities. It's causing, obviously there's been huge economic consequences to it. And that's probably the number one policy issue most of us have really been thinking of. And a lot of the tech policy issues we would normally be talking about, certainly in a transition, have been a little bit, to the side. But Julie, if you don't mind, maybe I'll start with you. COVID has also raised a tremendous number of privacy data protection issues and have brought related regulatory issues to the table. How are you seeing those develop and how are you dealing with them in your organization?
Yeah, it's a great question. And it really is the question of not just this year, but probably the next several years, if not this entire decade. Because what we found during the COVID crisis over the past 8-9 months, individuals and companies went through digital transformation that normally would have taken about 4 or 5 years in the space of 8 months. And that meant that everyone was moving to the cloud, everyone was connecting online. They had to. It was the way that people were working, were getting educated, were going to school, and the way that families and friends and communities were staying together. So these kinds of tools are going to be incredibly important going forward. As we get out of the pandemic, the polling that we've seen has shown that over 70% of people who have been able to work online would like to continue to work at least part-time remotely from their homes or from elsewhere. Now, and data has also been incredibly important, not just in terms of things like ensuring that we knew who was having the virus and trying to sort of track and trace and get people tested. But when it comes to vaccines and ensuring that the vaccines that are being developed actually do well in their phase 4 trials, which are coming up, we're going to be seeing a lot more data being used and a lot more personal data being used. At the same time, what we were seeing, all of this incredible use of data to help people stay connected, to keep communities together, there were a lot of gaps that were exposed. Connectivity gaps, we've heard a lot about that there were vast pockets of the population in the United States, as well as elsewhere around the world, who don't have sufficient broadband, who weren't able to keep their kids connected. So, huge gaps in terms of society and in terms of the ability to engage online. The other thing that we saw, and Microsoft, we saw this with respect to a number of our customers as well as other companies, there were a lot of public, as well as public health authorities, there were a lot of organizations who didn't know what they could do with the data they had during the pandemic in order to help bring people back and in order to help identify where the problems were with respect to the disease. Companies were not agile. Health authorities were not agile. because they didn't know what the guardrails were. They didn't know how they could use data outside of, say, since we have so many experts on the line here, outside of HIPAA, because much of the data use that we were talking about, what would be outside of the boundaries of HIPAA. The other problem and the other sort of gap, the gap that was really exposed during the crisis is that many people, while they need to use tech to stay connected, they also have serious concerns about what is happening to their data. Now, there were lots of reasons why people weren't engaging with tools that were made available, whether it was sort of the exposure notification apps or otherwise, lack of centralized leadership, a fractured public health system. But I believe that one of the reasons why we were less agile than we could have been is because we didn't have and don't have a national privacy law. I don't think that it would have solved everything, but I do think that it would have given people more confidence that data that is being asked for, their data that is being asked for and that would be used in these various systems would be protected and would be better protected. Lots of companies, including Salesforce, Microsoft, and many others, say, okay, even in the absence of privacy laws, here are our principles. Here's what we will stand up for. I issued a blog all the way back in April that outlined what our principles were for using COVID-related technologies. It was 7 privacy principles. These are the kinds of things that companies have to do in order to fill these gaps. But I think that COVID really exposed a number of problems that we have, including the lack of having clear guardrails about how companies can use data in a robust way, but also in a privacy protective way.
I couldn't agree with you more, Julie. And I have a couple of follow-up points, but I thought I'd turn to both Lindsay and Gabriella to follow up. Obviously, Lindsay, Salesforce very early in and I know Microsoft did too, but have been at the forefront of providing some of the tools that companies are using to actually help manage around this. And it's critical when those tools come out and they're being this widely used that somebody has thought about the privacy implications of all of the data. So do you mind talking a little bit about that from the Salesforce perspective? And obviously we're doing the same, but it'd be interesting.
Absolutely. Thank you, Justin. And I could not agree more with Julie's comments. I really think that the pandemic has just brought to the forefront and made really dining room conversation around a lot of issues on privacy that we didn't see before, and really see this turning into a broader conversation beyond the pandemic around data collection, responsible data use. And I really think about this as an area around data ethics as an exciting emerging area. There's certainly more and more laws and regulatory proposals in this area, particularly as it relates to artificial intelligence. But even in the absence of laws, it's really critical for companies to be thinking about the ethical implications of their data practices as part of their comprehensive data governance strategy. I have a fantastic colleague who runs our ethical AI practice, and she says that, while we're a technology company, we should always be human and society centered first and technologically second, because we know that no matter how good a technology is, people won't use it unless they trust it. And so developing technology with not only privacy, but I think getting broader into some of the issues that Julie raised around human rights and civil liberties are really, really important. And so I'm a lawyer by training, and I'm obviously very focused on legal compliance requirements, but I really think that the privacy community has been and really needs to continue to be focusing on these broader issues of not only what do we have to do or can we not do as a matter of law, but what should we be doing? What is the right thing to do? And I think the pandemic has just really put that at the forefront. And over the last 9 or so months in developing some of the tools that you mentioned, Justin, we've developed pretty advanced manual contact tracing applications, employee wellness attestations, shift management services. It's really been an incredible partnership to see. I lead Salesforce's privacy and product legal teams, but also partnering very closely with our Office of Ethical and Humane Use and really being side by side, virtually, of course, with product managers and engineers as we've created these products to make sure that we're getting it right and developing it, but also sharing best practices and setting defaults that are helping set our customers up for success in their use of these technologies.
Again, great points all around, Lindsay. And I'll ask another question or two here in a minute. I did want to turn to Gabriella to sort of bring it from what you're seeing in Europe. Gabriella, the same set of issues that Julie and Lindsay talked about in terms of how organizations, companies, countries are dealing with managing the COVID issue has very serious implications under European law as well. And I'm going to come to some specific questions, but do you have a reaction to some of the points that Julie and Lindsay just made, Gabriella?
Absolutely. And thank you so much for your remarks earlier, Julie and Lindsay. Especially the remark that Julie made highlighting how a lack of US federal privacy law impacted some of the effectiveness of the responses to the pandemic. And also I recall early on in April, I actually drafted and published a piece with the title, "Why Data Protection Law is Uniquely Equipped to Let Us Fight a Pandemic." And that is because precisely I saw that the European Union, thanks to the GDPR, had a bit of a head start, I would say, in allowing data to be used to fight a pandemic. And we've seen that the European data protection authorities have been very, very quick to react and to issue guidance on what companies and what authorities can do with the data, what would be an absolute not to do with the data. And that was because there was at least a serious level of legal certainty, even though we know that there are many issues of interpretation around some of the GDPR provisions. But we did have a set of rules that were comprehensively applying throughout Europe. And I think this also facilitated some of the best innovations we've seen in pandemic responses on the basis of data to happen in Europe as well. Because we've seen the pan-European research group that actually came up with the DP3T model for contact tracing mobile applications. And this protocol actually was later on considered as a basis for the Google and Apple contact tracing developments. And I would say that was a very important factor in effectiveness of replying with data to the pandemic. But it remains to be seen later on when we'll be looking at this period in time and paying more attention to data and results, whether it actually was also effective in practice. So that would certainly be my first reaction to this discussion, and looking forward to your questions.
Well, that's perfect. So let me jump off in a couple of ways. It has been very hard to move discussions on a national privacy law in the US for a lot of reasons. And I think we could probably just stop and talk about those reasons for the rest of the panel and talk about nothing else. But here's a question for each of you. Do you think this moment where we are trying to reopen, we do need to get people back to work. Even in this window, there's going to be a transition. And to be honest, it's very exciting to see these announcements where they're flying, the countries are flying, versions of the vaccine around the world to start being able to vaccinate those who are at highest risk. It's heartening, right? At the same time, there's going to be this window where you're trying to vaccinate, get people, the logistical nightmare around this is huge. And we do need to get folks back to work. Do we think that this moment of COVID might be sort of a point where you could at least get a first version of a national privacy law around that issue and then build around it. So I don't know if any of you want to jump in on that, but do you think we could get it done by starting with something like that?
Well, I'm happy to address that, and I'm sure others will want to as well. There are a lot of reasons for having a federal privacy law in the United States. Gabriella has highlighted some, I highlighted some. I also want to point out, though, that some of what was happening in Europe that Gabriella mentioned was not just a result of the law, but also a result of the privacy infrastructure that exists in Europe. And I think that that's worthy of a separate portion of the conversation. But with respect to, so it is certainly the case that Congress could consider a law that would be largely focused on COVID issues. We have seen some bills on that have been dropped on that, but I think it's worthwhile, Justin, in reflecting on that question, which I think is a really good one. The fact that actually what's going on in Congress right now is you have on both sides of the aisle, as we say, inside the Beltway, or as they say inside the Beltway, the Republicans and the Democrats have put forward very strong bills, even as the crisis was moving forward, but also beforehand, that actually align very well with each other. There is the basis for building a really strong bipartisan consensus, and there's more activity on this issue around a federal privacy law than I've seen in my nearly 3 decades working in this space of privacy and technology and competition issues. In addition to COVID being an impetus, we also now have the California Second Initiative, if you will, the CPREA, California Privacy Enforcement Rights and Enforcement Act, I think, or something along those lines. Many people just say CCPA 2.0. Also serving, I think, for some people as an impetus. So the stars have aligned before the crisis. I think it has the pandemic has caused the stars to align a little bit more, and there are other factors at play. We still have 2 issues that not only members of Congress, but also the stakeholders that have been very involved in the discussions have been unable to get over. And that is the related issues of how to provide individual redress and how to deal with preemption. Until we can find a way to bridge the gap with respect to those issues, I am concerned that we still won't, even in this crisis, even when we need to be able to have clear guardrails so people can be more agile with their data, even in this circumstance, we won't have a bill unless both sides start to take a step back and see, okay, can we start? Can we begin with looking at redress, looking at preemption, not necessarily as an all or nothing issue, either one of them, but as scalable issues that we can begin to address in a first attempt. So that's kind of how I see the landscape right now. Looking forward to what others think.
If I could jump in on that, Justin, I think it's just very interesting how the pandemic has brought a lot of these issues more top of mind than they were. I mean, obviously, fighting the pandemic, getting vaccine out is a critical priority right now, but that policymakers, regulators, individuals are very concerned about increased collection of their data and how it's used. And we've seen a couple of very COVID-specific privacy proposals, both at the state and the federal level, which I think are very interesting perspectives on it. But I think kind of going back to Gabriella's point about how data protection and the pandemic, so many of the laws that are already in place were really set countries and companies up for success in terms of how to work through these data challenges. is that the underlying principles of the COVID-specific bills, and I think what many of us are advocating for in terms of an overarching federal privacy law, are very much the same. I mean, the implementation might be a little bit different, but Gabrielle, I think I'm cribbing a little bit off of what I think you meant, and from reading your article earlier this year. But I think what a really great federal privacy law can do is not only address the challenges and opportunities that we're seeing right now around data handling and use, but also other crises in the future, more general use cases that we've seen. And so, but at the end of the day, I think the principles are really the same, whether it's COVID specific or not.
Fantastic points, Lindsay and Julie. Lindsay, I will pick up on your point that indeed we actually have seen bills being proposed both at federal and state level to particularly deal with collection and use of data for health research purposes, for COVID fighting purposes, and that has been a very good development to see. As far as I know, none of them were successful until now, but that was to be expected because we know, how complex the legislative process is in the U.S. And definitely, I see what's happening now with the pandemic as a great impetus to motivate more seriousness and more effort towards comprehensive privacy legislation. But to pick also on Julie's points that there are certain developments, quite strong developments, that are also very important motivators for a more serious debate around comprehensive privacy law. And the CPRA, CCPA 2.0 definitely takes the cake for that. But I would bring into the conversation also what's happening around the world. And I cannot not observe the fact that, for example, Canada, our very good northern neighbor here in the US, published a very, very modern, comprehensive privacy bill only 2 weeks ago. Look at China. China published a comprehensive personal information protection bill 2 months ago. And I think that all of the big markets around the world are right now so serious about this type of protections that I'm really hoping the US will sort of suddenly, wake up, honestly, and be that leader in this conversation that we know it can be.
Justin, can I just pick up on that point for one second? Because I think it's a great point. And the way I describe it is, in the United States used to lead on various international issues around not just with respect to data use, but all sorts of issues around international norms and conduct and things like that. When it comes to privacy, the United States is losing its leadership. And to Gabriella's point, it's not just Canada and China, but actually since 2018, when GDPR went online, you have many countries that have adopted laws that are designed to be interoperable with GDPR. And, we're talking about Brazil, India, Japan, South Korea, Thailand. In addition to Canada now revising its law in a number of other countries, New Zealand as well. It's because Europe has really, in many ways, and GDPR in particular, has become the global standard now that the rest of the world is looking to. And that isn't, I'm not suggesting that is a bad thing, but the United States is not part of the group of entities that is setting these global norms. We have lost our leadership our thought leadership in terms of setting the norms around how data should be used and how it shouldn't be used. So when it comes to that issue, I think it's really about thought leadership. And then to a certain extent, actually more and more, maybe to a great extent, US companies could start to lose their competitiveness to the extent that they do want to engage in the global economy, because they won't be built to adhere to and align with these global norms. So the absence of a US privacy law has a lot of implications, not just with respect to COVID and dealing with sort of state laws and trying to have a federal standard, one standard, but also in terms of the international conversation. I think we're losing our competitiveness on thought leadership and possibly from an economic perspective as well.
Julie, I couldn't agree more with that. And I think, in particular, I mean, we're both, working for very large multinational technology companies, and are fortunate to have a fair amount of resources at our fingertips. I really am worried about the impact on small and medium-sized businesses in that regard.
Yeah, definitely.
So, if I may, on those points, by the way, I'm not shocked that the four of us are high-fiving each. I mean, we're really all four of us in agreement on the need for this. I think there's no, for a lot of reasons. Julie, I know when you and I were in the government, for example, you could see that when there is a national US approach to something, we have a seat at the table on a lot of different fronts where you can say, well, look at our approach versus your approach. And there would be, with a national privacy law, some important stakes that the United States could put in the ground that are different, perhaps, than what GDPR would be. And, First Amendment considerations and others are probably on all of our minds in that regard. But one thing I think that's worth us asking each other at this point is, the train is moving so fast with other countries passing national laws. I think you're right to raise not only Canada, which is going to, I would bet, have one very soon that moves in this direction, but a lot of other countries. But then in the other side of it, you see states moving quickly. Funny, I mean, for all of the discussions around CCPA 1.0 and CCPA 2.0, or CPRA, as Julie, you were mentioning, there is a lot in CPRA that's very similar to GDPR. And just think about it, for the first time, all of these companies that are covered by California law are going to have requirements to do privacy impact assessments under the rulemakings that are started next year. Washington, Julie, I know, I don't know if you can speak about it, but, obviously have had a critical role in a lot of the processes in Washington, but it could be moving again. And, you have a few states there. At last count, I had 23 or 24 different states that were considering different versions of this. Now, here's the question. If all of this keeps happening like this, will it matter at a certain point whether the federal government passes a law, right? That's a question. And number two, you see the ways in which the federal law has been hung up by the 2 points that Julie has brought up, preemption and a private right of action. Honestly, it looked like Washington's law might have been stopped because of the inclusion of a privacy. I don't know the inside, but at least the reporting was around that. And Julie, you and I, and I think all of us know that when you get to a federal law, the input that the national security agencies and the DOJ has on a law is a third item when you get to it, that from, this is real inside baseball, but there's a whole interagency process that gets run at the federal level that has a very heavy input from that side that also has been a pretty significant impediment. So here are my two questions. One, will it matter? It sounds like a lot of states are going to move independently and the privacy laws are going to pass. And two, in light of those three challenges, even with everything going on, and even though all four of us think it should happen, is it actually going to happen? Those are my two questions.
Great questions, Justin. And I think it absolutely matters. And to the points that Julie raised about leadership and having a cohesive national standard, but also just getting back to, especially for small and medium-sized businesses, navigating different state laws is really just going to be untenable for them. And a lot of folks, analogize to, well, we've done okay with having so many different breach notification laws. Well, I may or may not disagree with that, but I think that we have to be looking at a privacy law as just very fundamentally different than a breach notification law. Breaches are something that do happen from time to time, but a privacy law really gets to the core of an organization and their use of data, and having different standards across the United States, especially for smaller companies, is just not going to be a tenable path forward.
Yeah, I agree, definitely agree with that, Lindsay. I would also say, we've seen this movie before in terms of the data breach notification issues. And one of the reasons why Congress was, in my observation, why Congress was unable to enact a federal data breach notification law is because, frankly, the business community was divided. Stakeholders were really divided over kind of where the chief responsibility should lie. I think that companies have largely been able to navigate the different state breach notification laws, but in some ways, notifying consumers is real about various issues is really what states do. Whether it's the Truth in Lending Act, the breach notification laws, there's various other federal laws that do give the states leeway to sort of say, okay, we understand that companies need to follow certain standards and have certain systems, but when they fail, when there's a problem, here's what they have to tell our users in our state. That is a state function. We're learning lots about state functions over the past several weeks, and I'm a really proud, former state regulator. I did it for 20 years, and I'm so proud of the way in which people are learning much more about all the great work that states do. And that's one of them, is how do you notify individuals when there are problems? And the federal government and Congress has sort of accepted that. To Lindsay's point, though, I think what really will matter in a federal law is, and having a federal law is that when you have to architect a data system and how that data system will work, how it will pull information and then provide information to users, that is the kind of thing that look, Salesforce and Microsoft, we're two, as Lindsay said, we're two companies that can probably handle anything on some level. But for the vast bulk of companies, it's going to be really hard to start navigating when you have rules that are different, that are focused on data architecture and system architecture. That's where it gets to be difficult. So I think it does matter from a policy perspective, but I do think states will go forward, as you said, Justin. And so it will be interesting to see what these state laws do look like and the extent to which they do affect sort of internal architectural systems and the extent to which they align with each other. The other thing that we saw with data breach notification laws is over a period of 10, 15 years, those laws more and more converged because the states were told, look, we can't handle these different systems. And so they did do more converging. I think the second part of your question, Justin, was, well, will we have one, or when will we have one?
When?
I think.
Yeah, do you have an over/under on number of years, for example?
Over/under. Well, so here's what I'd like to say, and I did see that someone put that question in the chat as well. We have a changing of the guard about to take place on January 20th. And we also are not quite certain yet what the lineup in Congress will be. But I do think that there is an opportunity. I don't know that it will be in the first few months or in the first year, but there will be an opportunity to do a reset on this conversation, kind of examining how close the different bills have been and trying to develop a consensus bill that may not be quite as ambitious as GDPR, but at least will move forward. I do think Congress has a lot on its plate and will have a lot on its plate. We have an economic crisis, we have a health crisis, we have a connectivity crisis. There's a lot of issues that I think Congress does need to address. I expect that they will be looking at a privacy law. My hope is that one would get passed within a year. but
Can we say you heard it here first? Are you?
You heard it here first if you want to. I'm all in on that. But I also I am hedging that because I do think that there are really big issues that Congress and this new administration will have, and we need to give them the space to do that. Privacy is super important, but there's a lot of issues out there right now.
I agree, Julie, and I was only, I get there's a
I
lot
know.
of things on the plate. And for me, the thing that I see as a challenge, and it's replicated in a lot of the questions we're getting from the panel, and I mean from the audience. By the way, it's just awesome to see so many people participating in this way. So we'll try to get as many questions answered as possible. But just look at Washington and look at what happened in CPRA. So CPRA has a lot of overlap with GDPR in a lot of really important ways. It's not exactly the same, and it does not have a private right of action. It passed, but look at the groups in California that opposed CPRA, including the ACLU and a number of other very prominent civil society groups. That's an interesting data point. In Washington, again, you're way deeper on this, and I know probably all three of you are, but in Washington, to see the bill, the last round, I don't know where it stands right now, but to have passed one house and then see that it seemed like the inclusion of a private right of action seemed to be a very big sticking point on it passing. That's just one of 20 issues that we know that will be in a national privacy law. And you see how complex it is, even where it's so overlapping with GDPR. So I think that's where I think there should be a lot of impetus about it, but I feel more worried about the ability, even if you had time and space to pass it, that we'll actually get it done.
I agree. As I mentioned before, these are the two big issues. Private right of, I like to call it redress. And the reason I call it redress is because, if you do think of privacy as a fundamental right, which we do, and I think Salesforce does, and lots of other participants and stakeholders do, people need redress of some kind if their rights are violated. The issue is, though, it really should be addressed at a federal level. When you start having these redress provisions that are very different in the states, it can be very hard to navigate. California does have a private right of action in CCPA. It's a narrow one, dealing with breaches, and it was not expanded in CCPA 2.0. But I agree with you, Justin. I think that the CCPA 2.0 really did a lot to close the gaps that we saw in CCPA around company accountability. And that's what it brought in or was inspired by with respect to GDPR. Purpose limitation, data minimization, the DPIAs, the data protection impact assessments, as you talked about. We see all of that in this new initiative. And those are really important accountability measures that have to be part of any robust privacy law.
Lindsay, Gabriella, I think great points, Julie, as usual. I agree with you.
If I can add something also with regard to the last round of question, just one data point to throw in the mix that was not sort of highlighted yet. Whenever the American people have the chance to directly say something about how much privacy they want, it's an overwhelming yes. And we have seen that with the CPRA. And despite strong opposition from the ACLU and other consumer organizations, the ballot initiative, was voted by close to 60% of the voters. But that's just one example. In Michigan, and this is not really broadly known, but Michigan is my home state currently. In Michigan, actually, the population voted close to 90% to amend the state constitution with a privacy protective article saying that law enforcement always needs a warrant if they want access to electronic communications data. And again, a resounding voice from Americans. Also look at Massachusetts, if I'm not mistaken, with the Right to Repair ballot initiative that has implications about accessing data on connected cars and being able to do some interventions there. And again, the ballot initiative passed. So I think this should also be taken into account at federal level, but at state level as well, sort of the will of the people. Clearly Americans care a lot about that. So that was one of the points I thought would be a good addition to this conversation.
Great point, Gabriella. Totally agree too. The one thing, and I'd like to hear from Lindsay too, the one country I will highlight on the new privacy law that is probably worth looking at it with a bit of a jaundiced eye is China. They have a very extraordinarily broad set of laws around government access, not only to the data, but to the code. And I suspect, I remember looking at this, and I suspect Julie and Lindsay are dealing with that regularly. But so I do agree. Your broad point about countries around the world passing laws that are protective of human rights and privacy rights. Our Wirewheel team is obviously crazily committed to this principle, but I do think there is probably a few places where countries are passing privacy laws that one might look at. Like if there's a North Korean privacy law, I'm not sure I'm going to be that comforted by it, for example. But I do think other countries like Canada, Brazil. Look at what Brazil has done in terms of leadership there. But anyway, Lindsay, and believe it or not, we're down to the last few minutes, but Lindsay, I want to hear from you, and then maybe we could each do one final point on this.
Yeah, well, just thank you for that, Justin. And just I completely agree with Julie's comments about redress or private right of action and preemption being the thorny points, but also just to address one of the questions that came, a couple of the questions that came up. I think another just theme that in my mind is actually a lot more solvable than the issues that Julie pointed out is some tension around being more prescriptive versus being more principles based, and I think that has a very interesting interplay with redress or a private right of action, particularly given the US legal system. But going back to, as I understand some of the civil society groups' oppositions to some of the California initiatives has been, the extent to which we're putting the burden on consumers versus the burden on organizations. And I think that that's just a very interesting area that, again, I think is very, very solvable. And consumers, of course, need to have rights and to be able to effectuate the kind of the various things in terms of access to their data and having choice, et cetera. But that needs to not be solely the focus. Organizations also have to be just more generally accountable for their privacy practices. And so I think that it's just a very interesting, not necessarily a tension, but conversation that's also happening in terms of the federal law and state laws.
That's a great point, Lindsay. Well, so I knew we would run out of time. Amazingly, we have each of you, and I would have another 5 questions. Like Julie, the idea that we're not asking you about some of the antitrust items that are actually out there publicly. Lindsay, there's so many things that Salesforce is in the middle of. Same with you, Gabriella, that I would like to cover. Since we only have a minute or so, I thought I'd ask each of you one question that maybe you could answer briefly, and then we can wrap it up. Or if you don't like my question, I'm doing this for each of you. I also know one of the 3 members of the panel would do this anyway. I'm not going to say who, but if you don't like my question, answer the one you would like to wrap it up. Okay, so here's my question for each of you, and you can pass on it. Julie, do you think we'll have a new law from Washington on privacy in this next session? Lindsay, do you think we'll have a federal privacy law in the next 3 years? Federal privacy, comprehensive privacy law. And Gabriella, do you think we'll have a new version of Privacy Shield in the next year? Actually, I'll say next 6 months. Next year's too long. So those are my questions I'd have for you, or you can answer your own.
Am I starting?
Sure.
And I know who you were referring to. So I'm going to answer both the question you gave me and the question you gave Gabriella. And when you talk about Washington, just to make sure the audience is quite clear, we're talking about Washington State.
Right. Correct.
Has had a couple of bills pushed through. I do think Washington State will likely pass something this year. I think because of COVID and a number of other things, and also because Washington State also already passed a facial recognition bill, which is very significant. We haven't had a chance to talk about that, but Washington State has been very forward-leaning in terms of a number of important privacy issues. In terms of Privacy Shield, I just can't, sorry, Gabriella, I just can't help but also answer that one. I do think we will have a replacement or a sort of augmented Privacy Shield, whether we call it Privacy Shield 2.0 or whether someone comes up with a better label. I think we will have a new framework between Europe and the United States within the next year as well.
Well, how about this then, Julie? How about you, if you feel comfortable, answer also the third one, and then we'll have all three of you answer all 3
years on the federal law? Yeah.
We'll have a federal comprehensive law within the next 3 years.
Yes.
Awesome. Okay. Lindsay.
Washington, yes. Federal law, yes. I think 2 years. I think 1 year might be a bit aggressive, but I go with 2 years there. And successor to Privacy Shield, I don't think 6 months. Don't get me wrong, I'd be delighted to have something within 6 months. But I think that's more likely to be by the end of 2021.
Got it. Perfect. And Gabriella.
I also think that Washington State this time around, I think this is the version 3.0, but I think this time around it's going to be successful. So I'm very confident in that for some reason. And actually the reason is that I know the debate has been so substantial in the past years. And I think everyone there is ready to actually, score the goal, as we say in soccer terms. And I do think that Washington State will happen. I'm very optimistic about federal privacy law as well, because the two leading bills that we are looking at, the one led by Senator Wicker and the other one led by Senator Cantwell, have so much in common, which is amazing to see, from a Republican and a Democrat led bills. So I do give it a very high chances as well, especially if your timeline is 3 years. And then finally on the Privacy Shield, I'm cautiously optimistic. I would say that everyone is absolutely engaged into pushing that one, over the finish line as well in the European Commission and here US side, and it might happen. I'm not as confident as with Washington State at all, but there is a good chance.
Awesome, Gabriella. Well, look, I'll take the same three. I will, or same questions. I'll say Washington will pass. Julie, I don't know, you have the ball. I think we're going to get that one done.
We'll run with it.
So I'm going to say Privacy Shield, especially after just speaking with Bruno. I think 6 months it'll happen. I think there'll be a new version of it. I think federal privacy law next 3 years, I'm more worried about. I'd probably say no, but I think in part because I think for the next year, there's going to be so many other things on the agenda that it'll be hard to focus on this, but I'm hopeful. I'm hopeful it'll come for all of us. For all of the other questions that happened today, let me just say, we covered a lot on the European section in the first earlier one. There'll be more discussion during the day. Our panel actually decided together not to cover section 230 because there was so much to cover just on the privacy front. We know that's a big issue. We do have a tech policy conversation coming next, and I think we can talk about section 230. That's certainly on a lot of folks' mind today because President Trump has stated that he's going to veto the defense bill without a repeal to the immunity provisions in 230. So I don't know if that's true or not, but that's what's been reported. But we'll cover those issues. And we'll also, there are a lot of questions that I think all of us would have loved to have covered today, but it just gives us a reason to have Julie, Lindsay, and Gabriella back. So please, I hope you will join us again. It's been an absolutely terrific discussion among the panel. And thank you again for each of you joining Spokes to share your insights. You know, we're very committed to getting this level of knowledge out to the whole community, to law schools, to those who are learning in the privacy community, and we do it sort of as part of our commitment to make it free and open. But I'm very grateful that each of you would take your time to come talk to our folks today. So thank you each. Thanks to each of you, Julie, Lindsay, Gabriella.
Thank you so much.
Yeah, thank you. Thank you, and that concludes this session. Thank you, Justin and panel. I'd like to remind everyone that recordings for this session, as well as all of the Spoke sessions, will be made available after the conference concludes. On your screen, you should be seeing the agenda for the rest of today. The next session is Tech Policy. What will the world look like in 4 years, which begins in just a couple of minutes here at 2 o'clock Eastern. We hope to see you there. Thank you and have a wonderful day.
Thanks, everybody. Hope to